Good morning, everyone. I want to thank you all for joining us today for our Q&A and webinar on policy enforcement in this new climate that we're in. My name is Kevin Holloway, and I'll be your moderator for today. Before we get started, I would like to go over a few housekeeping items. First, as with any technology platform that exists, especially with webinars, there is a potential for technical difficulties. So while we humans try to figure out how to deal with the technology, we appreciate any patience that may be required while we deal with this. Also, please make sure and feel free to take as many notes as you would like, but be reminded that we are recording this webinar, so you will have access to come back and get all the jewels and gems that our panelists leave after we are done here. And then lastly, probably very important, one of the most important, please make sure you keep your microphones muted during the webinar. You will have an opportunity to submit questions at the end of the presentation via the chat box. We want to make sure we keep the lines as clear as possible so we don't have any feedback. All right, and with that said, like I mentioned earlier, my name is Kevin Holloway, and I'll be your moderator. I am excited and honored to be joined today by two amazing leaders in Kevin Pennington and Barbara Holland from First Service Residential. And at this time, I would like for them to introduce themselves. So Kevin, I will start with you.
Well, thank you, Kevin. And as mentioned, my name is Kevin Pennington, and I am a self-proclaimed property management nerd. I've been doing this for about 20 years. All but 2 of those have been with First Service Residential. I benefit, luckily, from the perspective of having served on multiple HOA boards, both on the master association side and on the sub-association side, and from the homeowner standpoint, as well as the developer representative standpoint. Speaking of boards, I also serve on the local chapter of CAI's Board of Directors and Executive Committee. That's the Community Associations Institute. I hold a CMCA designation, an AMS designation, and a PCAM designation, as you can see there on the screen. And I'm responsible for a team of community managers, general managers, and department support staff at First Service Residential. And I spend my days doing business development, client relationship management, process improvement, innovation, and oh so much more. So thank you, Kevin, for that, for teeing it over to me. Thank you, everyone, for being here, and welcome.
Awesome. Thank you, Kevin. Very exciting resume and background. Excited to hear more from you today during our webinar. Barbara, what do you got for us?
Well, I'm originally from back east, a Ravens fan. I've been involved in community management and property management for longer than I like to admit. I am an author and an educator. I have a number of books that have been published over the years by the Institute of Real Estate Management that have been used as textbooks for people who are just coming into our profession. I've been with First Service for going on my 6th year here in Las Vegas. Prior to that, I owned a company called H&O Realty and Management Company, which was a full-service real estate company involved in community management, property management, and obviously also the brokerage. I'm thrilled to be able to do this with the 2 Kevins. I guess I'm the flower in between the 2. I enjoy things of this sort, and hopefully you all will also appreciate some of the comments that the 2 of us have for you all today.
Awesome. Thank you, Barbara. Thank you, Kevin. Listen, if you all are not excited about the group of panelists we have here, I don't know what will get you excited. So I'm really, really eager to hear from both of you. So before we kick over to some of the meat behind the webinar, I would like to just introduce First Service a little bit more. So who we are and what we do. So we are the leading residential property management company in North America. Our business is building and managing happy, healthy, and exquisitely run communities. We aim very intently to improve the resident lifestyles, to ensure that we enhance the property value for our residents, and also deliver exceptional service on a daily basis to the communities that we serve. This year, 2020, has marked our 40th year of doing business as First Service Residential. We've served many, many premier communities within the West Coast and across California, Arizona, and Nevada. And we are honored to be able to say that we have a portfolio of more than 1,400 associations within the West. very, very exciting for us. Our goal with these webinars is to share best practices, to keep your community's best interests in mind. We also wanted to make sure that we took some time to share a quick legal disclaimer. You heard our background from our panelists. You heard a little bit about me. We are not your attorneys, so this is not legal information. This does not constitute as legal advice, anything we're saying, but just good nuggets of wisdom for you to take and do with it what you will. All right, so as we move forward, I'll run through the agenda of what we'll be looking to do. So first, we'll talk about just some of the simple prerequisites for good policies. What does that mean and how can we prepare ourselves? Next, we'll be talking about the impact of COVID-19 on HOA policies and how that has affected all of us in the HOA world and how we can deal with that. And then next, we'll be talking about the future of policy enforcement, whether it is something that has impacted us from today moving forward or just in general, the future of where policy enforcement is heading. Then we'll end with a Q&A and then, of course, provide you all with a few resources to be able to take some homework away and some study time on your own. All right, and with that, I'm going to start with kicking it off with the discussion around prerequisites for good policies. I am very interested, Kevin, as I hear your background on the certifications you have, the history and the experience you have. Just give us some of what you consider the secret sauce for creating a good HOA policy that doesn't make you look like the bad person, you know, the person out looking to get people, but more so just trying to make the community better.
Yeah, absolutely. Thank you, Kevin. And it's a great perspective to have, that, you know, understanding that sometimes the HOAs can look like the bad guy. And I think that the secret sauce for an HOA policy boils down to one primary thing, and it's communication. And it's understanding that people move into homeowners associations for oftentimes a very specific reason. They're looking for consistency. They're looking for a quality of life that is offered by a homeowners association. So when you communicate with residents and have them understand the why behind a particular policy that's being proposed, that level of understanding that homeowners have oftentimes leads to greater compliance and leads to more agreement. You're able to get that voluntary compliance. So starting with explaining why a particular rule is being proposed, why a particular topic is being discussed. So it could be as a result of homeowner complaints. It could be as a result of a new law or ordinance that has come onto the books locally. It could be to prevent potential liability, mitigate a potential liability in the community. And it could be a rule, keep in mind, that is passed that isn't limiting in nature, but rather liberating in nature. So an example in our current COVID environment might be a rule that the association is passing to relax restrictions around basketball backboards or parking in driveways or things of that nature. So making sure that you're communicating with the membership to have them understand what it is that you're discussing and why you're discussing it. Also explain the process. Explain the process of rule creation to the membership so they understand what to expect. So for example, in California, there's a very specific process for rule creation, and that process is intended to require an opportunity for homeowner impact or homeowner feedback and homeowner input. So the homeowners understand what to expect. They understand that they have a role in the process. You're going to get a lot more of that voluntary compliance by the homeowners if they understand the why. You are able to explain to the residents kind of that value proposition in agreeing to be bound by a particular rule provides value to those homeowners, getting back to why they moved into homeowners associations in the first place. Make sure that you are listening to your membership. You know, you can do surveys of the membership relative to that particular topic if it's a rule that involves some amount of discretion. If it's something that is in compliance with a local law and there's not a whole lot of discretion, again, communication and education is key in that particular case. One of the other things that goes along with communication is communicating to those people who are following the rules and communicating the benefits of following the rules to the entire community. So consider adopting a program to recognize those people who are following the rules. And you could have something along the lines of a neighborhood pride award where you highlight a particular homeowner's front yard, for example, in a newsletter or a website, and you show the value complying with the association rules and regulations. One of the other things that you can show to residents if you are implementing a new rule that involves how the community is maintained is how that translates into property value. One of the ways to get that information is to work with a local realtor who's familiar with the area, who can help explain how a particular home value can increase if some particular rule exists in that community, which ensures consistency and ensures that the community operates and looks a particular way. So communication is key. That's the resounding answer, Kevin.
Awesome. You know what? It's you had a couple key points in there that I want to make sure I highlight. I think talking about communication, like you mentioned, but also communicating for understanding. I think that's a big point of it. You know, when you're explaining a rule or you're acknowledging a rule, sometimes it just feels like it's another rule to follow. But if you explain and communicate so they understand why that rule is in place and that policy in place, I think that's very big. So thank you very much for that. So as we continue to move forward, I would like to kick it over to Barbara and ask you some of your thoughts on the impact of COVID-19 on HOA policies. You mentioned you've been in the industry longer than you probably want to admit, so you probably have felt the shift of COVID impact probably a little bit differently than others who don't have as much experience. So please, what are your thoughts on the impact of COVID-19?
Well, first, I'd like to ask some questions. When's the last time you reviewed your governing documents? Did you see the word COVID in any of the covenants? What about infectious diseases? What about city and state emergencies? What about the ability to change rules without the normal notification process? These were some of the challenges that boards and management companies and community managers had. And we had a short fuse in which we had to respond quickly. We were being impacted by governors' restrictions throughout the western part of the United States. It affected board meetings. Can we have a board meeting? Can we have a workshop? What about the committee meetings? And for many communities that have lifestyle activities, can we still have aerobics in our swimming pool? Are the amenities being shut down? And to complicate this, we had to explain this to our homeowners. It doesn't help when a governor says, okay, you all can go into the pools, but the newspapers don't tell the homeowners what kind of restrictions do we have. And so all these things have made it extremely difficult. We are a people business, and all of a sudden, we have to rely upon technology to be a people business. In terms of Zoom, WebEx, they've always been there. We just never really used them. And so what happened was that we had to have emergency meetings. Some of these emergency meetings or workshops may have violated state laws. In order for us to sit down and talk to our attorney, we needed to get legal opinions about, well, what does this mean? Some of these restrictions were coming to us on a weekly basis and they kept changing. How do we communicate this to our residents? Email, flyers, website. We had a lot of community residents that weren't up to speed in terms of things like Zoom and WebEx. Forget about the fact that many of our managers were not up to speed. And so what Kevin talked before about consistency and transparency, all of a sudden the rules changed. And I give you an example. Parking. Many associations, you're not allowed to park on your driveways or on the streets. But guess what? Now you have the entire community living there. Your children that were supposed to be in college are with you. Your job may have been non-essential and you're living at home. Or you may have an essential job in which your company has asked you to work from home. And so you can imagine cars being parked on the driveways, parked on the streets. Do you tow? So one of the things that community managers had to do was to talk about a reality time of showing some sort of, asking our boards to show some sort of compassion. Let's relax a little bit. We recognize that we have some violations of rules and that we need to communicate to our homeowners that, okay, we're going to allow certain things to happen during this time period. We're going to recognize this type of situation and back off. We haven't completely changed the rules, and yet we had many residents that were saying, hey, you're not following the process. So a lot had to depend upon your own real estate division. Some real estate divisions said, hey, look, we understand that boards may have to make some changes right now in order to meet this crisis. One of the things I want to talk about is the cost factor. Besides the restrictions that were placed on us by government, there was a cost factor. If you wanted to open up your pools, and if you were allowed to open up your pools, if you were allowed to open up your clubhouse and so forth, we had to come up with rules very quickly. One of the things that First Service did was to provide the managers and the boards with a tremendous amount of information, not only from legal counsel, but information in terms of a practical application. How do we deal with this together? And I think that showed the strength of the company, the managers, and our boards, because we did do a good job of working together. Some of the things concerning in terms of delinquent homeowners, well, just to give one example, in my community was over 200,000 people that are unemployed. Are you really going to send them to collections? Are you really going to charge interest and late fees right now? Or are you going to try to work with your residents? And so much of our little boxes, this is our little box for the rules and regulation. This is our box for the governing documents. We had to work out of the box. And I think we all did a fairly good job of working with our residents, probably during the most challenging time for all of our associations. I've been in this business for over 50 years, and I can assure you this was one of the most challenging times. It beat all the other types of depressions that we had over the years, and this is something that I think we all can be proud of, because I think it was very important for associations and boards to show that we truly care about our residents. So in terms of brainstorming, one of the things I've told all of my managers is that, guess what? Zoom and WebEx is here to stay. In fact, we had homeowners who have never attended a board meeting ever are now turning on either through Zoom or WebEx and participating and seeing the process of what it's like to run an association board meeting. And hopefully we will find some new candidates that would be interested in becoming our board of directors. The other thing is that, and I call it the tennis court emails that go back and forth between homeowners or go back and forth between board of directors. We don't have to do that. We don't have to waste that time anymore. We can say to our boards, it's very obvious that you all don't agree upon whatever. It could be on a rule change. Let's go ahead and tune in. And here's the time, the date that we all can see each other face to face, because what this COVID has done has eliminated the people part of our job. We are gregarious by nature, and we've been taking that away from us. And that has caused extra anxiety, extra stress on everybody, just in terms of the day-to-day things that we used to do that we can't do anymore. So your boards, hopefully, and your associations have considered, hey, we need to relax, pull back a little bit, take into consideration the restrictions that we have. Let homeowners know specifically. The fact that you're parking on the streets right now doesn't mean that once we get past this COVID, you'll continue to do so.
Awesome. Thank you, Barbara. Appreciate all the information. And, for me, as I hear you and Kevin speaking to this, I hear a couple things that kind of connect some dots. So, as Kevin talks about communication and explaining the whys behind things for COVID and the impact of COVID, you hit very hard on how ill prepared you are, anyone can be for something like this, and how ill prepared you ever can be. So, I think it's how do you prepare to be ready to pivot when something does come up. So, what hit home with me is, as you talked about, when was the last time you looked at your governing documents to see exactly what you can and can't do? I think that's very important. And something else you mentioned is, how do you utilize every type of partner to be successful within your community when it comes to policy enforcement? You mentioned, how do you utilize your attorney, for example? Boards don't need to sit and try to figure this out on their own. They should reach out to some of the experts. So I'm really glad you hit on that. And as we talk about the foundation of what policy enforcement was, and then how we are currently sitting within policy enforcement because of COVID. Kevin, I'm going to kick it back over to you, as I'm curious as to what you believe the future of policy enforcement is going to look like, whether it is due to COVID changing something or just where the trend was already heading. I'm just curious of what your thoughts are on the future of policy enforcement.
Absolutely. Thank you. Great question. So I think in general, what we've seen here with COVID, and Barbara touched on that nicely, is that what policy for enforcement is going to look like for homeowners associations moving forward is going to be constantly changing. There are going to be things that a homeowners association is faced with that are unexpected, and things that require the association to pivot very quickly. I think that's what we've seen from the COVID example. And I think that, to Barbara's point about making sure that you are constantly evaluating your policies to have a little bit of foresight into what could potentially present itself as a challenge if the conditions were to change, is key for associations that want to stay ahead of this and not be continuing to play catch up. So in reviewing your policies, you're looking for things that are going to be relevant long term. And in adopting policies, you're looking for policies that are going to be relevant long term. And if you find policies that are out of date, take action to remove or revise those policies when you find them, and still, instead of waiting for that issue to arise when a homeowner raises it. Don't put in unenforceable rules in place. So, if you're looking at trying to have policies in the future that are in line with what you expect to occur in your particular community, don't overregulate. Don't put a policy in place that you don't, for example, have the resources to implement. And so that constantly changing and needing to be aware of what your policies are and how those could potentially affect what you want to happen tomorrow, next week, is important. But I think the second part of your question, Kevin, is in addition to how we've seen COVID affect what future policies might look like, is just kind of the general trend before COVID. And what I've seen that general trend to be is more and more homeowner involvement, whether that's by choice on the part of the homeowners or mandated by laws. I think what we're going to continue to see is that the process of creating rules in homeowners associations is going to be more and more, is going to involve more and more homeowner input. And we've certainly seen that in California, and I imagine that we'll see that trend continue. So it speaks to the need to be communicative with your residents. It speaks to the need to be thoughtful and intentional about the long-term effects of your policies and how those policies play into why homeowners want to live in associations, for that consistency and that quality of life. So those are the two things that I've seen as a result of COVID and as a general trend.
Awesome. Thank you for that, Kevin. I appreciate it. So as we kind of come to the close of the prepared speaking points of what we want to talk about, I know I sit here as the moderator with some very engaging questions that I'd like to ask you too, but I will wait and allow the audience to throw their questions in. So please make sure that you're submitting your questions via the chat box on the right-hand side of your screen. And we'll do our best to answer every single question that we get. If we can't get to all of the questions today, don't you worry. We will make sure we answer them directly as soon as the webinar is complete. But at this time, we will gladly take any and all questions that you have for Barbara or Kevin. All right. We have a couple questions starting to come in, so we'll go ahead and start addressing them as they are coming through. So the first question we have, 20-plus-year-old CCNRs leading to selective enforcement. So what do you do? KP, or actually Barbara, I want to come to you with having a lot of experience in this industry. So 20-plus-year-old CCNRs, how do you handle that?
You know, this is where you need to really talk to your legal counsel to be able to compare your CCNRs with changes in the law. It's not inexpensive to redo your CCNRs, and yet I've seen many associations here in Las Vegas considering updating their CCNRs. I think over the years, at least in our state, the laws have allowed association boards to have more choices in what they do than what was written, 20 some years ago. So I think that's something that you need to do is to look at your CCNRs, look at your state laws. Number one, to talk to your attorneys, but the other of what Kevin was talking about, what are some of the rules that we need to change? For example, one of the things in your CCNR may say that you can't conduct business at home. Well, there's a big difference of somebody like a CPA that doesn't have visitors coming to his home, but he can work from home, as opposed to me opening up a daycare next door to you. And that's a type of regulation that technically we have to enforce. You can't work at home. Well, does that make sense now when more and more people are working from home?
The only thing that I totally agree, Barbara, just the one add that I would have is, understanding that your CCNRs oftentimes, especially the older ones, if you're looking at a 20-year-old set, are written with an intention to be somewhat vague, an intention not to have all of those specifics in there, because the board is able to adopt clarifying policies in most cases to make that set of CCNRs relevant to what the community is going through in that particular case. So you may not have to revise your CCNRs. A lot of associations are having to Barbara's point, to make those documents relevant to what's going on. But first take a look to see if your rules and regulations or your community guidelines or whatever sort of clarifying policy that is within the discretion of the board can be amended to accomplish the goal that you're looking to accomplish. So, if you have a working from home prohibition in your CCNRs, check with your attorney, to Barbara's point, to see if you can clarify what type of working from home is allowable and what type is prohibited. Each attorney might have a different interpretation there, but look at which governing document you're looking to amend, because the process oftentimes is different, and one can be used to clarify the other.
Awesome, thank you. I think I have another question in the chat that I think kind of lines up with this one. So with that one talking about older rules and policies within the CCNRs, the next question is, how often should a board review governing documents? And kind of just to your point, Barbara, you said in the beginning of your speech, when was the last time so how often, in the KP, I'll start with you, Kevin, on how often do you feel community should do this?
It's a great question. I don't know that I have a hard and fast recommendation for how often, but what I would say is it probably depends on the document. So if you're reviewing your articles of incorporation, for example, you probably don't need to look at that one too often. But if you're looking at a document that affects the daily lives of the membership, such as the rules and regulations or architectural guidelines, that's something that you should be looking at on a regular basis. Now, whether you do that annually or every other year, is up to you as a board. It's probably based on when the last time you looked at that document was. If it's been 20 years, you're probably going to want to do that this year, to Barbara's point, to at least bring yourself up to speed on what is in those documents versus what you want to be occurring in your community. But I would say it varies depending on the type of document that you're looking at.
Barbara, any additional 2 cents from you? I think you're muted, Barbara.
we're coming to the end of 2020, and for many of us, it's not ending soon enough, that association boards should look at their policies going into the new year. We've obviously have completed a budget, but take a look at your rules and regulations. Take a look at your enforcement policy, architectural policy. This is your chance to confirm that, okay, what we have written is what we want to enforce and regulate in the new year. Now, you may have some laws that have changed that will require you to make changes in those various policies and procedures. But I think that's this is one time where associations should at least look at those policies and procedures, make some determination of whether or not they can change it. Now, often they may not be able to change it because it's going to require a CC&R. And so that's going to trigger you looking at your CC&Rs. For example, the parking issue that we talked about before, that you've decided that you really do want to have street parking. Right now it's a regulation that says no street parking because it's mirroring your CC&Rs. So do we need to try to get homeowner support to change them?
All right, thank you both for that. I want to shift a little bit and talk about some neighbor. We have a lot of questions about neighbor, either neighbor to neighbor dispute or neighbor involvement. So I'm bucket a few questions together. So with COVID happening right now, of course, there are a lot of mask policies. There's a lot of closures and things that are happening because of, to your point earlier, Barbara, whatever rules and regulations according to each state. So we have one specific question in the chat that talks about a community closing a park that became controversial. Then it reopened the park as long as you are socially distant and wearing a mask. We have another question talking about the expectation to wear masks inside of a condominium building, in the hallways and common areas, et cetera. So my question to you all as the experts is, how do you enforce some of these rules and policies that are a little bit more self-policing, and it is a little bit more of a neighbor-to-neighbor issue, as opposed to something the board can easily and actively follow up on? So whoever wants to take that one first. I think, Barbara, I'll come to you this time.
Well, you know, no one really wanted to enforce the masks or social distance, or they had the inability to do that. And then later on, in our state, it was mandated that you wear masks. So associations had to come up with, well, how do we enforce it? Now, for those associations that have on-site staff, it was a little bit easier. But we have many associations here in which they have a swimming pool, they may have a tennis court, but they have no on-site people, staff. So we had to rely upon the homeowners to make sure that they're wearing masks and social distancing. No one really wanted to write people up for that. And I think this is where Kevin talked about communication. And we talked to our homeowners, hey, we're all in this together. And to make this work for the good of our neighbors and health, that we need to band together, bite the bullet, and get with the program. Now, ironically, when masks starting to have designs possibly was the best thing that happened because everybody wanted to have a mask with a special design. But this is where neighbors really working together with the board.
Yeah. Kevin, were you got any additional thoughts?
Yeah, I completely agree with what Barbara had said, and I think that, you know, this is one of those areas where association counsel would really need to be consulted when a board is looking to establish a rule on, you know, anything that's related to health, you know, anything that's related to, you know, infectious diseases or any of those types of things, because you know, you could as an association define in your rules what is the appropriate time to wear a mask, what is the appropriate physical distancing, and all of these types of things. And an attorney might tell you that an association taking that position is assuming liability by defining what is and is not appropriate. So some attorneys might tell you that your rule should be as simple as defer to whatever the authority is on that particular topic. So whether it's the CDC or the county or the state, and require homeowners to abide by whatever those guidelines are. And then the other thing, to Barbara's point about communication, is to message to the membership, hey, look, we've been told as an association by our attorney that we could have potential liability if we allow this particular amenity, whether it's a park or a pool or a fitness center, to continue to operate if we are aware that people are not abiding by this CDC guideline or this state regulation or whatever. So as a board, we're asking for that voluntary compliance. We're asking for the self-policing, but if we don't see it, we're going to have to close the facility. So it's not the direct enforcement like you would see if someone had their basketball backboard out, where you're sending them a letter and calling them to a hearing necessarily, but you're enforcing that need for people to self-police. Otherwise, you're closing down that amenity, and you're communicating to the membership that we have to do this because we potentially have liability associated with it if we don't.
Awesome. Thank you both. Something I wanted to kind of sit on this for a little bit more is the neighbor to neighbor piece of it. I thought we probably more naturally would push into it, but as you both were talking, I think just the simple energy and effort to get the community to kind of be on the same page, specifically around masks, is enough detail in itself. So thank you both for that. Now with neighbor to neighbor, I'm curious if you all have any nuggets of wisdom or guidance. I know neighbor to neighbor disputes can be really tough. Oftentimes the HOA doesn't have a ton of authority in neighbor to neighbor disputes, but what advice do you have for boards trying to deal with neighbor to neighbor disputes, whether it is a policy or a type of policy to implement, or just some guidance that you can provide them? Kevin, we'll start with you.
Yeah, this one comes up, as everyone on the webinar probably knows, pretty often. And so one of the challenges that boards often face is, does the board decide to allocate association resources to mediate or solve this dispute, whether it's the management company's time, whether it's getting their attorney involved or spending time at a board meeting, whatever those resources are those association resources going to be spent to mediate a neighbor-to-neighbor dispute? And that's a tough decision. So what I would recommend to a board is to establish a policy on that in working with your attorney. At what point does an issue rise to an association issue? Is it when two neighbors complain about a particular home? Or do we respond if it's just one neighbor complaining? Does it need to be a type of nuisance that affects multiple people? Do we need to have that complaint in writing? What are the steps that a homeowner needs to go through? Hopefully they've talked to their neighbor. Encourage people to do that, because I think people oftentimes miss that first step. But prescribe for the members how the association is going to get involved and at what stage and what that's going to look like. And an attorney can help you with that. A lot of times governing documents will be enforceable by either the association or a member. So a member oftentimes in governing documents has the ability to enforce a governing document against their neighbor if that's appropriate, just the same as an association does. Not every set of governing documents, but some have that in there. So it speaks to the need to involve your attorney. But communicate, spell out what that process looks like, spell out the why behind the association's decision to either get involved or not get involved. You're still going to have some people that want the association to get involved every time their neighbor, their dog barks once, but if you can spell that out, it helps people understand.
Awesome. Thank you, Kevin. All right, so pushing into our next question, Barbara, this one's going to be for you. It's a more specific question, but I'll ask it in a general fashion. So generally speaking, when you have a rule or a policy that's in place that does not go with municipal guidelines, whatever city ordinances that exist, and you're shifting, how do you go about enforcing that? So that's the general question. And the more specific question that you can kind of use as a launch point is, this community they haven't followed municipal rules in respect to barbecue grills being a residence place. So now that they're shifting, they're getting a lot of pushback because the barbecue grill rules and policies are not in the CC&Rs, but this board has realized the city has a different expectation. So how do you combine those two and still enforce the policy appropriately?
The general rule of thumb is that my rule can be more restrictive than that of my city. It can't be less restrictive. It can be more. So let's assume that the city says you need to have at least a 5-foot setback, but our rules say 10. So that's something that is difficult to communicate often to a homeowner, because when they're getting a permit to, let's say they're going to build a pool in the backyard, their diagrams may show that 5 foot, and we have to sit there and tell them no, according to our CC&Rs, it needs to be 10 feet. So the first thing you have to ask yourself is whether or not you're less restrictive than the municipality. If you are, then you really need to make a change. No one needs a formal complaint against your association. No one needs to have a fine because you're not following the basics that your city has set up for you. So that's the first question. That's the first situation. The other thing I just want to mention, when Kevin was talking about the mask and social distancing of that previous question, we didn't have those rules. And so that required associations in talking with their attorneys to create those temporary rules. So if we're going to enforce social distancing or enforce the mask, we actually had to create the rules. The other thing I just want to mention is that a number of years ago, the federal government basically said to associations, you need to look at neighbor-to-neighbor issues. And the reason why they asked, or they almost mandated, that we look to neighbor, because of the potential discrimination. And that the association wasn't getting involved where disputes between two neighbors really did revolve around discrimination. And so what has happened is that more and more managers are looking at the dispute neighbor to neighbor, and to determine at what point in time does the association have to get involved with, if nothing more than just sending out a courtesy letter, as opposed to going through the entire enforcement procedure.
Awesome, thank you. I want to shift a little bit. We have a question from someone in the community that is in a 55 and better community. And the question is around with COVID. Of course, everyone understands at 55 and better communities, the age restrictions and limitations that exist within that community. With COVID, more children and grandchildren are starting to reside in some of these homes. Is there a process, a suggestion, or any tips and tricks you all may have to either reset some policies within this 55 and better community in terms of how long these children and grandchildren are allowed to stay on site, or just approaching the members? So just your thoughts around how do you enforce the 55 and better policies in COVID times, as we are dealing with grandchildren and children who may be living there a little longer term. And Barbara, I'm gonna come back to you for this one.
I have 2 senior communities, and this has been very much an issue. I think a lot has to do with the manager's relationship with the board and the homeowners. I find that my senior communities, they attend our board meetings. So many of them know who the managers are, and they've developed a relationship and trust. At the same time, many of the homeowners they want to continue to have their restrictions. And so we've had a number of situations where young people are living in the homes, and technically, they should be receiving a violation letter. What we have been able to convince our boards, at least my 2 boards, that we need to relax a little bit. Let's find out more what's happening. What is the situation of why the younger person's there? Is it going to be for a short period of time? What is that short period of time? And give some variances. This is where at the very beginning, when I was talking about the fact of we need to show that we care. We just can't always be black and white. There's a lot of gray, and COVID has really brought that gray to the forefront. And how we as managers and boards act, homeowners are going to remember this. It doesn't mean that we throw away the rule book, but it really requires some internalizing about the people aspect and what we can do with our families. And a perfect example is that some of these children, their parents, in order to work, were not living in the same state. And they were traveling back and forth. So in order to have a job in the first place. So there are times in which we have to check with our attorney, check the temperature of our board and our homeowners, and try to convince them that there was a human factor of why we were allowing some of these children staying at the community for a short period of time.
All right, Kevin, if you have anything to add, I want to make sure I offer you the chance.
No, I would just again agree with what Barbara said, and obviously going into that conversation as a board, you're going to want to make sure you're aware of where the foul lines are, as it were. So in a 55 or better community, there are governmental agencies that have some sort of authority over those communities, and there are foul lines. You can't have a certain percentage of residents under a certain age, and so just be aware of where those foul lines are. So when you are living in that gray area and trying to make those human accommodations that Barbara references and are absolutely necessary, you're aware of those foul lines that you can't violate. Otherwise, you get yourself in some real trouble. And then just back real quick to the barbecue one. One other way that you can help people understand if you haven't been enforcing a rule before, and you don't have a rule in place relative to the barbecues, is to understand, again, communicate why that's being enforced. And a lot of times governing documents have a restriction where a resident can't conduct activity that increases liability for the association, increases the cost of insurance, and that sort of thing. So you can message to the membership that this is a potential liability for us, this could raise our insurance. As a result, we have to take this step. So it clarifies that it's less of a subjective item and more of a requirement the board has to take.
Awesome. So Kevin mentioned earlier about listening to membership and letting that drive some of the policies. And I'm going to take that advice right now and listening to my panelists. What I've realized in the last two questions, both of you want to go back and add your 2 cents on the question before that. So I'll make sure that I'm allowing both of you to give your 2 cents. We have so much awesome knowledge that I should have known better. So please forgive me for that. But that is me listening to my members. But what I'll do is this conversation buddies up really good to this next question, which is when you're making some of these exceptions and you're waiving enforcements, what is the best way to document that you are waiving enforcement of certain rules, or what's the best way to have a paper trail to either come back appropriately or to just kind of protect yourself on the back end from waiving these? So Kevin, I'll start with you, and then Barbara, I'll come to you after KP.
Well, obviously, you're going to want the board to pass a resolution on it. This shouldn't be something that is done without a formal board decision. And again, I hate to keep going back to the attorney, but work with your attorney for what their recommendation is going to be. But oftentimes, you might have an attorney recommend that you adopt a temporary rule. And a lot of the rules relative to COVID were adopted in emergency situations and in our temporary rules, and be aware that there's a follow-up to that to the extent that you want to continue to have those rules in place. But the cleanest way is to revise the rules until such time as you want a different rule, and to communicate again to the membership that this is what we're doing, this is the why, this is what you can expect to happen when things normalize, and we'll communicate back out to you when that happens and go from there.
All right, Barbara, got anything you want to add?
Well, you place these potential changes on an agenda. You notice that you want to create both the positive and the negative, as far as some of the restrictions, for example, that we talked about, the masks, versus those that we allow some of the restrictions to be relaxed. So from your newsletter, Kevin talked about this before, the e-blasting, attending meetings via the virtual technology that we have, place the temporary rules on the agenda. So now it's on the agenda. Now the board's going to talk about it. You may have a homeowner forum. We're required to in Nevada to have 2 homeowner forums where homeowners can participate and add their comments. And eventually the board's going to make a decision. That's going to be part of the minutes. So there's your documentation, the notification to the homeowners, the agenda, the board minutes. And in the minutes and the motions that are being made, a number of our associations said that they will relook, for example, on the late fees. We're going to hold back on the late fees. We had a lot of people that have been unemployed here. We will relook at it in October, or they'll give some sort of time certain. And so the homeowners that are at the meetings, homeowners who request minutes, newsletters that go out after the board meetings to let people know what's happening. Again, a documentation, we're going to relook at this in October. We're going to relook at this in 3 months. And so that's what you have to do. And again, what Kevin spoke about before, just the importance of communication. And you may find out that homeowners are very much against certain restrictions, and you have to take that in consideration.
All right, so we got about 10 minutes or so left, so we got a few questions to get through, and I'll try to get to all of them to the best of my ability. So next, I want to talk about short-term rentals. We have a couple of questions in regards to short-term rentals. So I'll ask kind of both of the questions, but first, just the fact that there are a lot of short-term rentals in one of these communities and the homeowner is getting cited for whatever violations are existing, and there's just nothing kind of happening with these renters. The renters don't seem to care. The homeowner isn't as impacted because they're not there. So how do we better manage that? And the other question around short-term rentals is just the fact that some homeowners abuse the policy, or they abuse their ability, and they're not following rules specifically. So how do you follow up on a homeowner utilizing or abusing their ability for short-term rentals? Like, how do you follow up on that? And the second piece around rentals is, how do you enforce rules, or what's a good way to enforce those rules amongst renters? So Barbara, I see that smirk. Smirks normally mean you got something good you want to say, so I'm going to start off with you on this one.
We're losing the battles in the state Supreme Courts. If anybody really follows any of the state Supreme Courts, the courts do not see any real difference between a short-term rental and a homeowner in terms of, well, what are they doing? Well, they're living in the unit. Are they causing any problems? No, they're just living in the unit. They go to work, they eat there, they sleep, they go use our common facilities. And so for many courts, especially the East, as it's moving towards the West Coast, we're losing that battle. So we have to look at that. Now, it all depends upon, your CC&Rs, but if you have flexibility, one of the things that you may want to consider is, okay, if they're going to be here and if we're going to have to deal with them, then let's talk about our rules and regulations that are specific to the short-term rentals. The other thing I want to mention is that more and more municipalities know that they can make money. I'm on a committee for Clark County talking about the fact that Clark County looks like they're going to change their regulations. And when they told us how much money the county and the state was losing in taxes for people that have short-term rentals, in terms of getting permits, things of this sort, it was amazing. So the trend right now between the courts and the municipalities that we can earn money is really contrary to many of our governing documents. What we've asked Clark County is that if you're going to pass a regulation that allows here to have short-term rentals, that we want the enforcement section that when that homeowner says, I do not live in association that in its governing documents prevent me from having a short-term rental, that if later on we come back to the county and tell you that person did not make an accurate statement, they do live in association, we do not allow short-term rentals, then we want to see some enforcement from the county that would basically disenfranchise that person from having short-term rentals in our county.
Yeah. Kevin, what are your thoughts?
I'll try to be quick. So yeah, Barbara mentioned on the enforcement side, municipalities, and that can be an avenue that a board can pursue if your local municipality has a restriction against the type of rental that is occurring in your community. You can reach out to them for their assistance in enforcing that as well. Sometimes people respond differently to cities or counties than they do to the homeowners association. The second thing is Barbara mentioned that the trend with the laws that are being passed is more and more relaxation on rental restrictions is what we're seeing. And we saw that, in California, for example, 2 or 3 days ago, the governor signed an assembly bill that further relaxed those restrictions. So this is one of those instances where you really need to work with your attorney to make sure that whatever restrictions that you want to put in place or that you have in place are not in violation of some recently passed law, because then they're unenforceable. But as far as assuming you've got restrictions in place that are in compliance with the law and you're now trying to enforce those, one of the ways that most associations can enforce rules is through restricting access to amenities. So for example, if you have a short-term rental, oftentimes one of the draws for that short-term rental is that the renter wants to use the pool or wants to use the association amenities. And if the board removes temporarily the ability for that homeowner to use those amenities, turning off their key fobs, whatever that is, that can make that rental less marketable and hopefully drive some compliance in that regard.
All right, thank you. So I'm sure we have time for at least one more. I'll try to get to multiple if I can, but this one is around being proactive or allowing the community to kind of do what the community does and kind of voice concerns. So the question is around, are we seeing more associations being proactive in terms of utilizing security cameras and monitoring these cameras to find violations? Or is it more so that residents, neighbors are calling in any violations, and anyone that may be using security cameras will go back and review these security cameras, but it's not a proactive approach? So is it more proactive follow-up with the use of cameras, or more kind of just waiting for it and being more reactive? Kevin, I'll start with you.
Well, cameras are always a challenge. And again, back to the attorney. So you want to have that, that feedback when you have a camera in place, because depending on where it's pointed, you could be running into some issues. But what I've seen, generally speaking, is that most associations, when they have cameras in place, they're using those to review after the fact when something occurs. Because if you have someone who's actively monitoring cameras, that's a live person who's sitting there looking at a camera feed all day. And most associations just don't have the resources to do that. There are some, I would imagine, that have that level of resources, but most don't. So when I've seen cameras in place in homeowners associations, they're generally used to review after the fact, figure out, what occurred in a particular situation, whether it's a violation, damage to the common area, something along those lines.
Barbara, what are your thoughts?
Well, cameras bring a lot of liability because there's an assumption that the association has a responsibility in terms of maintaining a peaceful environment as far as crime. And so you need to be very careful. We had a situation where in one of my associations, they were arguing that the cameras should have protected their vehicle. Well, the cameras were meant to take care of certain things that were common area amenities. It was not meant to be a camera that is going to prevent somebody from breaking into your home or vandalizing your car. So you have to be very, very careful with the cameras. People need to understand what the cameras are for. A perfect example is driving into your community. Many associations have a camera. Well, the camera is there to regulate, it's more of a traffic control as opposed to I'm going to catch somebody. So I think you have to keep an eye on that. As far as homeowners, because so many homeowners are living at home right now, more so than what we have normally, I think they've been a little bit more observant in terms of what is happening with their neighbors, residents, guests, and are calling or writing to the association boards that they feel that some sort of violation letter needs to go out.
Yeah, awesome. Listen, we are literally pretty much right at noon. We can go on about policy enforcement all day. Not only could this panel go on just because we have a lot of things we'd want to talk about, but we have a lot of great questions in the chat box. So for the questions we weren't able to get to today, we're going to do our best to continue to go through these questions and answer them directly for you and reach back out to you. But at this time, this does conclude our Q&A section of the webinar. Thank you, Barbara and Kevin, for your very thoughtful and energetic thoughts and questions, or thoughts and advice around the questions. So what we have here for you are just some additional resources for you to take a look at. So for those, Arizona, California, Nevada, you have everything you need right here. Go ahead and click this link, and please feel free to continue to reach out to us, use whatever resources we may have available for us to be able to help you. Even if it's not us, we truly believe in asking questions, raising hand, and getting the help and support you need. As an industry, we need to move things and move the needle as a whole. So with that being said, I would like to thank you again, Kevin, for your time today as a panelist. Very, very thankful to have you on this panel. Appreciate all your wisdom and insight. Barbara, same to you. Thank you for your time today. For providing us all of your knowledge as well. And with that being said, I bid you all adieu. Have a wonderful rest of your day, everybody. Bye.
Thank you, everybody.